Welcome to page 7 of the NEFAR suggested form of purchase and sale agreement. The very top of that page repeats what I said on the bottom of page 6, that if the binder is forfeited by the buyer to the seller, then the listing agent gets half. And that's what it says in lines 322 and 323. And it says that in the NEFMLS suggested form of listing agreement as well. Now, what happens if the transaction doesn't close, but nobody breached? What's the most common example? Well, there was a contingency that wasn't met. The buyer has the free look period during the inspection, 10, 15 days, whatever you fill in and the parties sign. That's a free look for the buyer, so the buyer can simply terminate, and that's not a default. Or if the buyer didn't get the loan, that's not a default. These next two paragraphs are very unique. I've not seen any other contract forms in Florida that do what we do. And for many years, we've done this. We say that while neither party breached, one party ought to reimburse the other for the fact that it didn't close, so some costs were incurred. So if buyer fails to perform but is not in default, for example, they canceled during the inspection period or they didn't get the loan, they're obligated to reimburse the seller for the survey map, the estoppel letter, if those things were incurred. And it does say, however, that if the reason it didn't close was it didn't appraise, then nobody has to reimburse anybody for anything because both parties thought it was worth the price. It didn't appraise. It's kind of a surprise to everybody, and nobody should reimburse anybody. That's the logic. So what happens if the seller failed to perform? That's really rare, like they're in bankruptcy or there's so many judgments and tax liens. It's really rare. But in that case, they would have to reimburse the buyer for the credit report, the inspections, the appraisals. What about in paragraph 12 if there's a binder dispute? Unfortunately, sometimes the transaction didn't close and the buyer says, I'm entitled to the binder back. The seller says, no, I'm entitled to the binder deposit. What do we do? Well, if the real estate broker is holding the binder, then the real estate broker can ask the Florida Real Estate Commission for an escrow disbursement order. And the FREC, Florida Real Estate Commission, would send an investigator to look through the files, talk to the people, and give an opinion as to whom the broker should disperse the binder. And if the broker follows that opinion, they won't be held liable for damages. However, if the binder is held by a lawyer or non-lawyer settlement agent, title agent, then we can't ask FREC for an escrow disbursement order. FREC won't take it. They have no jurisdiction over us. And we would have to try to get the parties to agree or to arbitrate, or in the worst case scenario, we'd have to interplead the money in court. If there's a pathetic binder like $1,000, here's what I would do. I would contact the buyer and seller and say, please come to some agreement. Because if I interplead this money in court, you'll be arguing over nothing. Because the court will give me an attorney's fee for bringing the interpleader action. That would use up $500 of the $1,000 approximately. They would reimburse for the service of process. That would probably use up $300. And they would reimburse for the filing fee, which would use up all the money. So hopefully we don't get into those situations very often. But that's what that non-default or default is about in the binder dispute. Now, we have a second really important part in this paragraph 12. It says, in the unlikely event that the parties are litigating between the buyer and seller, and they might drag the broker into it, they've agreed that it would be a non-jury trial. We know that jury sympathies would go for maybe the buyer, maybe the seller, but probably not the broker. So we put in there it's a non-jury trial. You can get to trial quicker, and the emotions won't be in there. And we also say that other than interpleader, if there's a dispute, that each party pays their own attorney's fees. That's held down litigation terrifically in Northeast Florida. If they know that they each have to pay their own attorney, then likely they're going to reach a settlement, or at least more likely they would. New subject, paragraph 13. In what I think is the most important law case ever to affect what we do for a living, the Florida Supreme Court in the mid-1980s handed down a decision known as Johnson versus Davis. Two all-American names. I think every realtor should know Johnson versus Davis by name. What the court there did was look at a situation that went something like this. Some buyers were looking at a house they wanted to buy. They Buyer wife looks up at the ceiling. She sees a spot. She says to the seller wife, "What is that?" Seller wife says, "It's a wallpaper glue." That's wallpaper glue. So the buyer makes an offer. They said they'll pay a $10,000 binder now, 10 more thousand in 10 days. And they signed a contract for approximately $300,000. During the 10 days, the buyer went over to inspect, and it began to rain really hard. And when the buyer looked up at that mark on the ceiling, they discovered the seller had lied. That wasn't a wallpaper glue spot. That was a wet spot, because when they looked up, water was leaking. So the buyer refused to pay the second installment. The seller had the nerve to sue them. The case went to the trial court, the District Court of Appeal in Florida, and to the Florida Supreme Court. And in Johnson versus Davis, the court made law. The court said, "We declare it to be the law of Florida that where the seller of a home knows of material adverse defects that are not readily observable, they have to disclose them to the buyer no later than at the time of contract." Material defect means it's important. It's not a $10 item. Look at the language in the contract. We literally use the Supreme Court language. If you look at line 357 and 358, it says seller represents that seller has no knowledge of facts materially affecting the value of the property other than those which buyer can readily observe except. Now, what's a buyer going to put in those blank lines? If the buyer's been made aware of a condition that the buyer accepts, they would put in there, a small freezer in garage doesn't work well. Generally, they'll put none or leave it blank. Listing agents, when you get the offer and if there's none or blank, you need to say to the seller, "Do you know of any latent defects?" That's kind of a synonym. And so the seller has to disclose those things that are presently defects that are important and are not readily observable. For example, if the driveway is full of cracks, you don't have to disclose that. It's readily observable. But there have been a lot of cases since Johnson versus Davis that says things that are not readily observable have to be disclosed. So make sure you give a lot of thought to that when you accept the offer. The next two lines comply with a Florida law that says if the property is under a code violation citation, then the seller must disclose that to the buyer. That's not very common. Most buyers are going to leave that blank or put none, and most sellers will go along with that. It's very rare that there's a code violation. Then we start 371 with some of the required and optional disclosures. Sub A, energy deficiency, is a required disclosure in Florida. More than 20 years ago, the state legislature passed a law that says buyers of a property for occupancy, and that can include a commercial property, have to disclose, sellers of a property being occupied have to disclose to buyers that they have the right to get an energy audit. And so we put that language in there. In my experience, very few buyers get the energy audit, but they could. And then the next one is required radon gas. To my knowledge, Northeast Florida has very little, if any, elevated radon gas. But this language, word for word, has to be in the contract. There's a Florida law that requires that. We'll continue that discussion on the next page. We're now concluding page 7.